Good to have you with us. Red Robinson and the Diner coming up in a very few minutes. Our final segment with our guests from Murphy Battista LLP. First, however, Joe Murphy and Brian Brook in studio on this episode of The Law Show. We've been talking about personal injuries of all sorts of descriptions. And Brian, you were telling us just before the break, but we were talking about waivers, whether it's the parent permission signing thing or whether you, the adventurer, go somewhere fun and they make you sign this before you go anywhere. All of those, Joe said the parental consent forms, sign them, they're worth nothing. What about waivers? Are they, well, you said they're very cleverly crafted to the advantage of the person who is asking you to sign.
Absolutely. One of the great ironies in the industry, Sterling, is that if these companies that are providing adventure sports took the same care with the safety and the welfare of their customers as they took with crafting and getting the waivers signed, far less people would be badly injured in these activities. And I think I said before, my impression is that the way waivers have been treated by the courts in British Columbia have allowed a lot of these companies to really slack on their standards because they know they're going to get off.
Right. Don't the courts have some appreciation, though? I mean, I grant you that they've made this. There's law now, case law in BC that says the guys with the waivers generally get off the hook. But where's the sympathy for the individual who signed the waiver in a fit of adrenaline, and it was prior to the adventure, and everybody has to sign it. It's pro forma. That's what we all have to do.
It's a really, really challenging area of the law, particularly for people who are badly injured after signing a waiver. It's a really challenging area of law for lawyers. I can give you an example. Way back when, lawyers would look at these waivers and say, well, the only real way to get around the waiver is to have a client who's Swedish and doesn't read English and didn't know what it was and comes from a part of the world where they just don't deal with waivers day to day, and just plead simple ignorance.
Right.
They say, you can't bind me to the terms of a contract, which is what a waiver essentially is, that I couldn't read and didn't understand were there. Okay, that makes good walking around sense. Okay. But where your clients speak English, they're not Swedish, and they're sort of sophisticated business people who deal with contracts and waivers on a, from time to time basis, it's really, really tough to make that argument.
Sure.
By way of example, I had the pleasure and the privilege of representing a young mom who signed up for a mountain biking skills camp at one of the hills, ski hill during the winter.
And I'm sure mountain bike paradise in the summertime.
Absolutely.
Right.
And she'd been on this camp a couple of years in a row. She was a business lady. She was a sophisticated, intelligent person. She'd signed waivers a couple previous occasions, and on this particular occasion, signed up for a 2-day mountain biking skills camp, went up to the ski hill, and on the first day, during what was supposed to be a lunch break, was taken to the terrain park, which is an area that has a whole bunch of different features, teeter-totters and jumps and things like that, where you get to sort of test your technical skills. In any event, she's taken into this terrain park during the lunch break, and the instructor gets her to try to do a terrain feature that's unmarked, but is clearly a double black diamond, the highest complexity level you can get. And she has a very unfortunate accident that leaves her quadriplegic. And for her, suck it up and get on with life just wasn't an option. She's got 2 teenage kids,
right.
And being a quadriplegic.
But she had signed a waiver, hadn't she,
She had
Brian?
signed a waiver, and she was an honest lady, and she was a bright lady, and she said, I signed a waiver. I'd signed something that was almost identical a couple years before. I know what they are. I've dealt with them in my business life. I'm not going to be disingenuous and try to pretend I didn't know what was there or what it meant. And the challenge was, how do we get around this potentially legally binding document? And when I looked at it, I sort of thought, well, yeah, you signed on to go on a mountain biking skills camp over the course of 2 days. And you're going to be riding this bike, you're going to be riding down trails, doing cross country and downhill. But after you signed that waiver, they introduced a new and unusually dangerous activity into the whole deal. Right. And you can't just do that. Get somebody to sign off on A and then introduce B, C, and D into the deal and say, well, you already signed away your rights to deal with that. In this case, she had never signed on to be taken into a terrain park on her lunch break and introduced to an unmarked double black diamond terrain feature and told it was suitable for her skill level. That argument that by introducing a new activity into the deal that she had no advance notice of when she signed the waiver, that the waiver couldn't be stretched to cover that, really, I think, resonated with the insurance representative who flew out from London, England, to deal with the case. It was a difficult claim. It was an injury that was devastating not only to this young woman but her family. Happily it was resolved. But it did point out, the real challenges that people and lawyers have to deal with when these waivers are presented.
Did it go to trial, or did the insurance company wisely settle?
The insurance company paid quite a large chunk of money here, and one of the tragedies is where you're in the position of this young woman with kids and a severe spinal cord injury. She simply couldn't afford to walk away from the money that was on the table and run the risk that the courts were going to get it right. And that was sad. Happily, some of her basic care needs over the course of her life are going to be taken care of. Unhappily, we didn't get an opportunity to try to right the laws in the province of British Columbia that I think see a lot of people getting shafted on the basis of waivers that are just unfair.
A lot of people don't know, Joe Murphy, that when indulging in sporting activities, we're talking about skiing or mountain biking, in some cases, your homeowner's insurance covers your activities in remote places like ski hills and mountain bike trails. How does that work?
Sterling, most people think homeowner policy applies to your house.
Yes.
But in fact, there's a part of the coverage that's called liability or third-party liability coverage that covers what the insureds do anywhere in the world. So I have a homeowner policy, and if my house burns down or someone steals the furniture, that gets covered.
Sure.
But if I go to a ski hill anywhere in the world, and I'm skiing and not watching where I'm going, and I run into someone, then my homeowner policy will cover the claim arising from that.
That's amazing.
So it really covers anything that I do anywhere in the world except operating a motor vehicle and except work activities. And people don't realize how broad the coverage is. I have the maximum amount of liability coverage on my homeowners because I know it's going to provide me with that coverage. So oftentimes, if you're looking at a ski case where there's a collision between a skier and a snowboarder,
and that happens, yeah.
Everybody lives somewhere, and quite commonly, there's an insurance policy that will provide coverage. I had a case of a young university student who literally ran over a client of mine at Whistler, and they were a university student living at residence, but their parents' homeowner policy, and the parents lived in Victoria, provided the coverage that paid my client for his injuries. So the homeowner policy covers your house, but the liability policy covers just about everything else.
Well, friends, if you've not learned anything else from listening to this episode of The Law Show, there's a keeper. There's the take-home message from this show, and there have been several, and I'm grateful to both Joe Murphy and Brian Brook for it. But, Brian, it's you look at some of these things you pay for year after year after year, and all of a sudden there's a dimension to them you didn't even know about.
The great thing about British Columbia, Sterling, is, and Joe and I think, are the first people to say that despite the appearance that ICBC is the great enemy of lawyers, we both recognize that in terms of the bang for the buck you get for your insurance money buying coverage, ICBC offers a fantastic product at a really good price. There's no other place in the world you can get $5 million liability coverage for the cost you get it in BC, assuming you're a good driver. Homeowners coverage, likewise, in British Columbia, it's relatively cheap. And
would the same provisions apply, by the way, to tenants' insurance as they would in terms of liabilities?
There's third-party liability coverage in a tenant's. And that's one of the reasons why a tenant should have the policy, not because they've got $1,000 worth of furniture that someone might steal, but rather that there's a liability claim. So if I'm a tenant and I leave a tap on and building floods, my homeowner tenant package pays the claim. In the same way, if I go skiing and run over some poor fellow on the ski slope, it pays that claim. So the coverage, the liability coverage is very, very broad.
Excellent information. My thanks to Joe Murphy and Brian Brook from Murphy Battista LLP. Online, by the way, at murphybattista.com. All the contact information, phone numbers, email addresses right there on the website. Joe, Brian, thanks for coming in, fellas. We'll see you again soon. See you next time on The Law Show.